We're going to talk a lot about civil cases and criminal cases, but in the judicial system, you should know that the vast majority of trials, or excuse me, cases, court cases, don't go to trial. And the reason for that is the lawyers from either side want to reach a deal to avoid kind of clogging up both the courts and also potentially the prisons. They want to get a resolution done. So 90% end what we call a plea bargain, where the lawyers agree to terms. And this can be where the prosecutor, which we'll talk about what that means in just a moment, and the defense lawyer decide that the client or whoever's being tried could plead to a lesser sentence to avoid having to go to trial and get a jury involved and a judge involved and all that kind of thing. This is especially true if the person's guilty. So if they know they have you, they've got all the evidence. It's just why tie up the court system? You're going to plead guilty potentially anyway, or be found guilty. You could plead to just a little bit less sentence. It's an incentive to just get it over with and end it in a plea bargain. This does also, though, sometimes lead to people pleading guilty for things that they didn't do, which might seem weird. But the reality is that people think juries are risky, and they are. You're putting your life's fate in the hands of somebody else and people on a jury. And sometimes the penalty you're seeking, or they're seeking for you, like a life sentence, if you could get that reduced to 10 or 15 years, even though you didn't do something, people often could and have pleaded guilty to things. So that's just the kind of the reality of plea bargains. Like I said, they serve a good function, but they could be used in ways that aren't great. As far as trials themselves, there's some key vocabulary you need to know. So if you have a criminal trial court, these are for kind of felonies or gross misdemeanors that involve some type of major violation of a state law or a federal law, but in most cases it's a state law. Burglary, murder, driving under the influence of alcohol carries potentially a jail or prison sentence, or a major fine. A civil trial isn't necessarily have to be a formal trial. It's two people having a disagreement that needs to be resolved through the legal system, potentially just with a judge. And so it could be just a contract dispute. It could be money. It could be like child custody. But civil is person to person. Criminal is the state coming after somebody else for a violation of state law. So we're going to go into more detail of these, but in general, these are the basic vocabs. Both systems are adversarial, meaning it's kind of one side against the other side, and that's kind of how our legal system works. I want to start with the basics of the court system in Washington state, but really it's the same in basically every state. So you have at the lowest level, you have what we call district courts, which are kind of at the local or county level. If you're in a really populated area, you'll also have city courts. We don't really have that here, but you may have that if you lived in a really populated area. What you usually see, though, at the lowest court level in a state system is the Superior Court. That's at the county level, and they can hear all sorts of cases. And so it's kind of like a regional courthouse based in every county. And so that's what we have here in Washington state. And then the next level up is the appeals court. There's only a few of those scattered throughout the state, and they hear cases after the decision's been made. And then every state has the Supreme Court, and there's only one of those at the state capitol.